Thank you, Your Honors. The Office of the Prosecutor has failed to meet its burden in the indictment or during the course of the trial to specifically identify the subordinates over whom it is alleged that General Mladić had effective de jure or de facto control, for whom it is alleged they performed criminal acts for which he is supposed to be responsible. In reference to Srebrenica, paragraphs 21 through 22 of the indictment, the so-called Scorpions unit are added to this laundry list of alleged perpetrator actors over whom General Mladić is alleged to have had effective control, or for whose acts he is said to incur liability, but limited to their involvement in Turnovo. Paragraph 34A of the indictment sets forth that General Mladić failed to initiate investigations into credible allegations of crimes by Serb forces under his effective control. But an accused's position of authority cannot lead to an automatic presumption that he or she knew or had reason to know of the crimes for which a conviction is sought. This is from paragraph 313 of the Mladić appeals judgment. The mental element had reason to know, as articulated in the statute, does not automatically imply a duty to obtain information. Responsibility can be imposed for deliberately refraining from finding out, but not for negligently failing to find out. This is from the Mladić appeals judgment, paragraph 406. Essentially, the Office of the Prosecutor has neither properly pled a sustainable case for the command responsibility element, had reason to know, nor has the evidence established a sustainable case for the same, especially as to non-VRS actors and perpetrators. In this section, I ask you at the Rule 98 bis stage to remove the Article 7.1 and 7.3 motive liability as to charges where the evidence cannot sustain that motive liability for specific perpetrators. As a preliminary matter, we would point out that there does not appear to have been credible evidence presented by the prosecution of the involvement of any specified VJ personnel in any of the crimes alleged, let alone evidence of how VJ personnel would be subordinated to General Mladić. As for the other alleged perpetrators, we believe that the Chamber should look at the actual evidence that was presented and appraise whether there is evidence to sustain the burden under Rule 98 bis, demonstrating that actual units of the VRS or under the effective command and control of General Mladić were alleged to have committed crimes for which he is charged, or if the evidence is such that other persons, known or unknown, over whom General Mladić did not have effective control, are alleged to have committed these crimes according to the evidence. The prosecution has not adduced any proper evidence that General Mladić issued any criminal orders to individuals who are alleged to have been the perpetrators of the crimes set forth in the indictment. Indeed, as to Srebrenica, prosecution expert witness Richard Butler confirmed that with respect to July 1995, his research had not come across any document or order from General Mladić specifically ordering the execution of prisoners. This is transcript page 16,573 through 16,574. It should be recalled that there was only one witness who claimed General Mladić personally participated at one of the sites in Srebrenica, providing cloth to tie the hands of prisoners. That was RM 255 at transcript page 1177 through 1178. This is purported to be the 16th of July and was evidence that had not been previously stated by the witness. Your Honors, there has been evidence presented in relation to General Mladić's absence from Bosnia from the 14th to the 16th, when he was, among other things, participating in meetings with international negotiators and attending a wedding in Belgrade. Indeed, the prosecution has stipulated as to most of that period of time that General Mladić was far from Srebrenica, and indeed, during the testimony of RM 255, the prosecution, Mr. McCloskey, in fact, said, quote, "Perhaps one thing that may help. I just wanted to be able to tell the court that it is not the prosecution's intention to rely on this most recent evidence related to General Mladić or Karadzic. I wanted to bring that out so that you could see that. I think we've asked him, perhaps too much of this witness, but we will not be relying upon that," end quote. This was transcript page 1179 through 80, right after the witness testified about this alleged personal involvement of General Mladić. So clearly, Your Honors, this type of evidence is not capable of belief. As to the municipalities, there has not been evidence capable of belief that indicates General Mladić ever ordered crimes to be committed. I wish to focus on crimes committed by paramilitaries and others that are not in the VRS. First, I will demonstrate that the evidence supports that General Mladić did not have effective control over them, specifically in relation to Arkan's Tigers and the MUP. In several incidents, either the perpetrators were never identified or were identified as paramilitary or police members. The record demonstrates that General Mladić, early on, 28 July 1992, issued an order, P501 in evidence, calling for the disarmament of paramilitaries. This order is critical to show General Mladić's lack of criminal motive and efforts undertaken to try and curb and punish crimes by paramilitaries. This order directs that if intentions of paramilitaries are truly honorable, they should submit themselves to become VRS soldiers subject to control and discipline. For those that have committed crimes, it is said they cannot be taken into the army, but should be disarmed, arrested, and criminal prosecutions started against them. Those that refuse to turn over to army discipline and command, but that have not committed crimes, are to be arrested and escorted out of the country. It is clear that General Mladić had no hand in the prior actions of these various paramilitaries. Problems effectuating this order are apparent from P5116, dated 17 August 1992, where General Mladić again asks subordinate units why they have not reported on the disarming of paramilitaries pursuant to the aforesaid order. That these groups continued to plague the territory of Republika Srpska beyond the command and control of General Mladić is evidenced by P3095, dated 23 September 1995, with General Mladić complaining to the RS President and the RS Police about Arkan's Tigers, considering them a paramilitary that has been operating outside the command of the Army and committing crimes, including against loyal Muslims, and asking that the President and police undertake to take action against that group, since it is operating apparently as a member of the MUP police and pursuant to a directive from President Karadzic. Also in evidence we have P5133, dated 26 September 1995, where Assistant MUP Minister Kovac and another high-ranking police official seek to meet with General Mladić to resolve, quote, certain problems with regard to the commanding of troops currently under the MUP, end quote. Again, from the timing of this document, it is clear who is being talked about. Thereafter, we have P5065, dated 19 October 1995, another order coming directly from General Mladić to remove paramilitaries, reading as follows: all paramilitary formations and individuals who refuse subordination in the VRS are to be removed from the territory of the RS by 20 October 1995 at 1200 the latest. All illegally obtained military technical devices, combat equipment, military and other equipment is to be seized from them and the proper receipts issued to them. Investigations are to be launched and the proper proceedings initiated for all illegal offenses committed, all disciplinary, misdemeanors, and criminal offenses. Again, it is clear, not just for Arkan's Tigers, but for all paramilitaries, they are not operating with the blessing of General Mladić, nor under his command and control, nor are they undertaking acts intended by General Mladić. Prosecution military expert Tunins testified under oath that Arkan's unit was subordinated to the State Security or the DB of the Republic of Serbia. You can find this at transcript page 20,683 to 20,684. This is corroborated by P3095, which we have just discussed. There has been no evidence suggesting nor establishing by requisite means that General Mladić is the command superior of the Serbian State Security Service of the MUP of Serbia. Accordingly, all charges that have been alleged to be the responsibility of Arkan's Tigers should be dropped from the case at this time, as that charge cannot stand. As to other non-VRS actors, it should be recalled that we have in evidence P5052, an order from General Mladić dated 2 July 1992, expressing concern of unauthorized armed persons in uniforms masquerading and operating as if they were officials of the army and police while conducting crimes. This order makes clear the main staff only issues written orders, not verbal ones, and that all suspicious units should be checked, while regular units should wear proper uniforms, and that units should prevent such impersonators from engaging in combat unless they pass security checks and submit to be incorporated into the army as regular soldiers. Let's talk about MUP forces themselves. In relation to the events in Srebrenica, and indeed municipalities, there has been some evidence presented by the prosecution that the members of the MUP had been responsible for crimes that are alleged against General Mladić. Some instances that come to mind are the killings in Kravica and the killings at Trnovo. From the foregoing documentation as to paramilitaries, we see that General Mladić did not have effective command and control over these units when the same were operating under the auspices of the MUP. The same result is true for civilian MUP police once they have finished operating in combat operations. Returning to expert tune-ins. This prosecution expert explained the concept in the SFRY military of sadejstvo, or coordinated action, during operations, where two forces operated alongside one another without actual subordination. This is transcript page 20,616 through 20,617. Mr. Tunins further explained the concept of resubordination or reattachment of the MUP to VRS Army units for limited purposes. Transcript page 20,621. Mr. Tunins described that once combat operations are done, the police returns to their police function and their police superiors. And thereafter, the VRS Army commanders in the region can only thereafter report MUP wrongdoing to the police authorities, and the MUP superiors have the responsibility of any further disciplinary or other actions. This is transcript page 20,622 through 20,625. Your Honors, we have seen General Mladić do precisely that in relation to Arkan's unit. He did all that a military leader can do with relation to police personnel not under his authority. We think that under these circumstances, the crimes alleged to be committed by MUP members alone, such as Kravica warehouse, must be dismissed from the case as to General Mladić. Indeed, OTP investigator Mladić confirmed the Petrovic video, which follows the actions of police units around Srebrenica and part of the scene at Kravica. Mr. Mladić confirmed that General Mladić is not seen anywhere in relation to that video. This is at transcript page 12,373. One further thing I would like to point out: the so-called Scorpions group at Trnovo, the infamous video of their killing of 6 individuals. P2581 is that video. It was played numerous times by the prosecution. However gruesome the video, and however repulsive and reprehensible the actions of these scorpions, they have nothing to do with General Mladić. OTP investigator Jans testified that Mladić is neither present in any part of the Scorpion video, nor is he mentioned by the perpetrators therein as having any role in the killings. This is transcript page 15,378. The best testimony before this chamber that is suited to illuminate the events in Trnavo was very explicit and resounding in clearing General Mladić of any involvement in this crime. The evidence is clear. The Scorpion perpetrators never mentioned General Mladić, but rather always were clear their superiors were the Serbian DB and the MUP Assistant Minister for Serb Krajina. This can be found at transcript reference 18,710 through 18,711. The evidence as to Trnavo is also clear. The Scorpion unit itself was operating in coordinated action, as described by Mr. Tunins, rather than being resubordinated to the VRS. This is at transcript page 18,715 through 18,717. The perpetrators from the Scorpions themselves were not engaged in coordinated action with the VRS at the time of the crime, but rather were described as bodyguards, a driver, a mechanic, and a member of the kitchen staff engaged in personal acts. This is at transcript page 18,729 through 18,730. The evidence is clear these perpetrators have been tried and are serving sentences in Serbia. There is no role of General Mladić in ordering or taking part in these killings in any way. The perpetrators were not subordinated to him, thus he could not discipline them. There has been no evidence of how General Mladić ought to have known of the crimes. Accordingly, this charge should be dismissed. Another topic that I wish to raise at this point is Tomashica, which we have heard the prosecution claim is a mass grave that Mladić's own notebooks confess culpability in. Respectfully, P358, page 154 in E-Court, the notebook cited by the prosecution in question, does not support the prosecution's case. In it, Mladić is being told of a police official's comments as to Tomashica. General Mladić makes clear the VRS knows nothing about those bodies, that the police may be trying to pass their own misdeeds to them. General Mladić directs that investigations be carried out as to those bodies. Again, for crimes committed by persons from the police outside of his effective control, this evidence cannot lead to criminal responsibility for Mladić as the VRS main staff commander. Turning to the incident at Schedule A 7.5 of the indictment, Skrljevita, spelled Skrljevita. One witness was called in relation to the same, Grgo Stojic. Your Honors will recall that during the testimony of this witness, it was revealed that the perpetrators of this crime never once mentioned General Mladić. This is transcript page 4125 through 4126. Further, it was demonstrated by the witness himself that the principal perpetrators of the same were aged 15 and 17 years, respectively, at the time of the commission, which leads to the conclusion they were not VRS soldiers. and that the other alleged perpetrator, arrested and prosecuted by the authorities in Republika Srpska, could not in fact be identified by this witness. This is at transcript page 4112 through 4120. Indeed, at transcript page 4109 through 4110, the witness confirmed the Banja Luka military court, already in November 1992, ordered that all alleged perpetrators be taken into custody for the murder and investigations launched, for the murder, and that investigations be launched, all this shortly after the crime occurred. At transcript page 4110 through 11, the witness confirmed that the military police of the VRS identified the perpetrators, including minors who were outside the army, and conducted an on-site investigation. Exhibit P369 is the indictment that was raised by the military court against the perpetrators, condemning the crime. Your Honors, there is thus no credible evidence of belief that persons subordinated to and under the effective command and control of General Mladić could be said to have committed this crime, or that military organs under his control failed to investigate and prosecute the perpetrators. Accordingly, this charge should be dismissed. I have highlighted concrete and clear examples. For the record, the prosecution case as presented involved paramilitaries or MUP personnel as perpetrators as to the following Schedule A incidents. 3.3 Ključ, 6.7 and 6.8 Prijedor, 9.1 Vlasenica. The prosecution evidence fails to particularly identify the perpetrators or differentiate amongst them as to the following incidents from Schedule A. 6.1 Prijedor, 6.5 to 6.6 Prijedor, 6.9 Prijedor, 7.3 Sanski Most. The prosecution case, as presented, involves paramilitaries or MUP personnel as perpetrators as to the following Schedule B incidents. 1.1 Sanski Most, 1.2 Sanski Most, 10.1 and 10.2 Novigrad, 13.1 to 13.4 Prijedor, 16.2 Vlasenica. Meanwhile, the evidence fails to particularly identify the perpetrators or differentiate them as to the following from Schedule B, 2.1 Bijeljina. As to detention centers, the defense points out that Omarska and Keraterm were police facilities. Based on the evidence presented, the prosecution case cannot stand as to these charges. General Mladić is reputed to be a key member and or principal perpetrator in an overarching joint criminal enterprise lasting from October 1991 until 30 November 1995, with the objective to permanently remove Bosnian Muslims and Bosnian Croats from Bosnian Serb acclaimed territory. This is paragraph 5 of the indictment. The indictment sets out an additional but related joint criminal enterprise aimed at eliminating the Bosnian Muslims in Srebrenica and spreading terror among civilians in Sarajevo. This is paragraph 6 of the indictment. General Mladić is alleged to share the intent for the commission of genocide, persecution, extermination, murder, deportations, and forcible transfer with other members of this joint criminal enterprise. This is paragraph 8 of the indictment. Alternatively, General Mladić purportedly could foresee that the crime of genocide might be perpetrated by one or more members of this joint criminal enterprise and willingly took this risk. That's paragraph 9 of the indictment. The defense challenges the evidentiary base presented by the prosecution in relation to the mode of liability, a third category of joint criminal enterprise, for purpose of a no-case submission under Rule 98 bis of the Rules of Procedure and Evidence. Our position is that the prosecution has not presented sufficient evidence to render a conviction supporting the charge that General Mladić shared or intended to further the common purpose of the JCE. The defense would like to remind Your Honors of the separate and dissenting opinions of Judges Hunt and Benauna in the Celibici case. Quote, "The fundamental function of the criminal law is to punish the accused for his criminal conduct and only for his criminal conduct. We believe that taking into account abstract elements creates the danger the accused will also be convicted of additional crimes which have a distinct existence only as a purely legal and abstract manner. Effectively, through the historical accidents of the way in which humanitarian law has developed, in streams having distinct contextual requirements. The fact that the articles of the statute encompass different, although frequently overlapping, crimes is a result mainly of the history of international humanitarian law rather than any indication that they are intended to describe genuinely distinct bodies of criminal law in contemporary international humanitarian law." End quote. Before this tribunal, the Tadić Appeals Chamber stipulated that it is only appropriate to apply the notion of common purpose in relation to a joint criminal enterprise where the following requirements concerning mens rea are fulfilled by the accused. 1. The intention to take part in a JCE and to further, individually and jointly, the common purpose of this enterprise. And 2. The foreseeability of the possible commission by other members of the group of offenses that do not constitute the object of the common criminal purpose. That's paragraph 220 of the Mladić appeals judgment. With your leave, Your Honors, I will address evidence relating to the requirement that General Mladić willingly entered into the joint criminal enterprise and supposedly shared and furthered the common purpose of the same. Subsequently, I will address evidence relating to the requirement that General Mladić could foresee the crime of genocide being committed. We submit that the prosecution has not shown that the accused willingly entered into the joint criminal enterprise. The mere position General Mladić held within the VRS cannot be used as primary evidence to infer his criminal responsibility. Doing so would militate against the principle of personal guilt. Rather than distinguishing between the accused and the specific crimes for which he stands trial, this concept degenerates into a smokescreen which obscures the frail connection between General Mladić and the acts for which he stands trial. An accused's position of authority cannot lead to an automatic presumption that he or she knew or had reason to know of the crimes for which a conviction is sought. That is again from the Mladić appeals judgment, paragraph 313. And again from Mladić appeals paragraph 406. The mental element had reason to know does not automatically imply a duty to obtain information. Responsibility can be imposed for deliberately refraining from finding out, but not for negligently failing to find out. Essentially, the OTP has neither properly pled a sustainable case nor has the evidence established a sustainable case for the same. We submit that the prosecution has not proven that General Mladić agreed or supported the common purpose of the third category of JCE in relation to the crime of genocide. The defense recognizes that the proper scope of JCE 3 is not completely settled in international criminal law. This is supported by Judge Shahabuddin's conclusion to his separate opinion in the Burgenin appeals judgment, quote, a physical perpetrator has to be a member of the JCE for a member of the latter to be criminally responsible for a crime perpetrated by the physical perpetrator within the common purpose of the JCE by predicating the need for an agreement expressive of the intention of the parties. That position respect the essentials of the principle that criminal responsibility is only assigned for one's own conduct, end quote. An agreement expressive of the intention of the parties, as referenced to by Judge Shahabuddin, requires the prosecution to prove that the accused by his acts or acquiescence is part of such a JCE agreement. This is paragraph 4 of Judge Shahabuddin's dissenting opinion. The Krajišnik trial chamber held that persons in a criminal enterprise must have engaged in concerted action. This is the Krajišnik trial chamber judgment in paragraph 884 and is also referenced in the Krajišnik appeals chamber judgment at paragraph 192 through 194. The defense recognizes that it is established case law before this tribunal to render convictions under the third category of joint criminal enterprise for specific intent crimes such as genocide. Nevertheless, we would like to give notice to Judge Liu's recent partially dissenting opinion and declaration to the Shayinovich appeals judgment. Judge Liu recognized that genocide requires that the perpetrator's intent goes beyond the mere prohibited, and that as a consequence, the mens rea required for specific intent crimes is incompatible with the standard of advertent recklessness applied to a third category joint criminal enterprise. In the absence of evidence of specific genocidal intent, no conviction of genocide may be entered. Furthermore, Judge Liu finds the words of Antonio Cassesi persuasive. Quote, "Whoever is liable under the third category of JCE has a distinct mens rea from that of the primary offender. Nevertheless, as the secondary offender bears responsibility for the same crime as the primary offender, the distance between the subjective element of the two offenders must not be so dramatic as in the case of crimes requiring specific intent. Otherwise, the crucial notions of personal culpability and causation would be torn to shreds." And indeed, a further discussion of this can be found in Cassesi's book, Limits of Individual Criminal Responsibility under the Doctrine of JCE, pages 121 through 122. The defense submits that in light of Judge Liu's dissenting decision, the prosecution has not provided enough evidence to point out General Mladić's specific intent, and therefore he is entitled to dismissal of the related charge. Evidence shows General Mladić did not share intent related to any common purpose that has been identified by the prosecution. Prosecution witness Manojlo Milovanović, in his testimony on 19 September 2013, attested to that fact. His testimony pertained to Directive 7, a directive issued and signed by the Supreme Commander, Mr. Karadzic. General Milovanović explains that unit commanders should not take any measures based on directives from Karadzic, which should have been sent to General Mladić instead. In this particular instance, Directive 7 was sent to all the Corps commands. This was an instance of duality or double lines in the chain of command. Corps commanders should not have reacted to Karadzic's directive before receiving Mladić's orders as a result of the directive. The task assignment to the Drina Corps by General Mladić in Directive 7.1 was not taken over from Directive 7. The General left two things out in Directive 7. The first is the controversial sentence that unbearable conditions have to be created for the civilian population of Žepa and Srebrenica. The second element left out is the sentence referring to the separation of Srebrenica and Žepa by force. General Milovanović states that the accused exercised personal responsibility when he decided not to pressure the civilian population and thereby not adopt every element from Karadzic's Directive 7. This clearly shows that General Mladić did not share in any nefarious intent that could be attributed as arising out of Directive 7. In addition, Exhibit P 3095, relating to General Mladić's demand to withdraw Karadzić's authorization to the paramilitary formation Arkan's Tigers. This evidence shows that the accused did not share any nefarious intent that could be attributed to Karadzić or other alleged JCE members. The demand specifically mentions the arrest and abuse of non-Serbs and requests the MUP to take measures for the crimes they committed and to disarm this formation, which was operating pursuant to authorization issued by Supreme Commander Karadzić. Your Honors, evidence shows that the accused did not share the intent and common purpose of the joint criminal enterprise to permanently remove Bosnian Muslims and Bosnian Croats from Bosnian Serb acclaimed territory, and our position is that the prosecution has not presented sufficient evidence to the contrary. Furthermore, the defense would like to remind Your Honors of the difference between commander responsibility liability and liability under the head of a third category JCE, as clarified in the burgeoning appeals chamber, and to keep that in mind when deliberating over this evidence. As outlined before, the defense will now address evidence relating to the requirement that General Mladić could foresee the crime of genocide being committed by other alleged members of the JCE. The Tadić Appeals Chamber stated that everyone in the joint criminal enterprise must have been able to predict this result. It notes that more than negligence is required. The standard applied to the third category of a JCE is that of dolus eventialis. Lack of agreement between the members of the JCE risks that one or more of the perpetrators goes outside of the purview of the common purpose of the enterprise. A JCE warrants a common understanding and mutual attribution of the conduct of the participants, and our position is that the JCE doctrine is not the appropriate instrument to sustain a conviction of General Mladić's alleged genocidal intent, nor has the prosecution presented sufficient evidence in this matter. We believe this position to be in line with the reasoning of the Kwočka Appeals Chamber judgment at paragraphs 91 through 92. The indictment alleges that General Mladić was aware or could foresee a genocide happening. The Tadić Appeals Chamber dealt with the same matter and stated that, quote, uncertainty in the mind went to the question whether genocide would in fact be committed, not to acceptance by him of it, if and when it was committed, as something which he could predict as the natural and foreseeable consequence of the activities of the joint criminal enterprise to which he was a party, end quote. It is important for purposes of our 98 bis submission, in relation to foreseeability, that General Mladić's intent to commit the crime of genocide must be shown to include the specific intent to commit genocide even when he did not know whether or not genocide would be committed. I would like to remind Your Honors that Tadić was not convicted of the crime of genocide. Furthermore, the Tadić Appeals judgment stated, that it is still necessary to show intent, and that this was shown by the particular circumstances surrounding the JCE. Former Judge Cassesi shared his view on foreseeability. He was of the opinion that the foreseeability standard is neither precise nor reliable. It almost introduces a form of strict liability, as it will be for the prosecution to prove that the participant had knowledge and willingly took that risk of a specific fact or circumstance, evincing the likelihood that the other participant might commit an unconcerted crime. Furthermore, he stated that clearly, if the prosecution fails to prove all this, the charge must be dismissed. It would be contrary to the principles of a fair trial to shift the burden of proof and require the defense to prove that the accused did not know the relevant facts nor foresee the crime and willingly took risk that it be committed. Again, this is from page 117 of Proper Limits of Individual Criminal Liability under the Doctrine of JCE, a publication by former Judge Cassesi. In his dissenting opinion to the burgeoning interlocutory appeal decision, it is said the third category of joint criminal enterprise does not dispense with the need to prove intent. What it does is that it provides a mode of proving intent in particular circumstances, namely by proof of foresight in those circumstances. And again, we're talking about Judge Shahabuddin, paragraphs 4 through 5 of his separate opinion. In light of the common understanding and mutual attribution of the conduct of the participants and the particular circumstances surrounding the JCE, the defense would like to draw Your Honor's attention to Exhibit P 4283, a decision by Supreme Commander Mladić. The decision pertains to Mladić's attempt to reassign Mladić to a position outside of the main staff. This attempt is corroborated by prosecution witness General Mladić. Your Honors, I would like to quote page 17,106 of the transcript, where Mladić says, quote, Mladić started about speaking renaming the main staff into the general staff. I asked him whether all of those present should be listening, and he said that everybody else should leave except for Krajisnik. And then he said to me, General, we are renaming the main staff into the general staff. General Mladić will be replaced, and he will be the special advisor for defense for Republika Srpska and the Republic of Srpska Krajina. And I shot back by way of a response, saying that I would not be head of that general staff. Krajisnik added, Radovan, let him be now. This is an initial action on the spur of the moment. As a soldier, he will have to receive his orders. The order did arrive the next day. Again, I refused it, even in writing. That is to say, all generals of Republika Srpska refused and signed a petition to the Assembly of Republika Srpska. It was the Assembly that appointed Ratko Mladić as head of the main staff. So it is only the Assembly that can relieve him of that duty, not the President, end quote. Based on the foregoing, the most reasonable conclusion on the evidence is that there was no common understanding of the type alleged by the prosecution. And the attempt of President Karadzic to reassign Mladić is highly indicative in the circumstances of the alleged JCE that try to exclude the accused. Our position is that the prosecution has not proven sufficient evidence to prove otherwise. I think we're at the time for a break. We could take one now before moving to my last comments.
If this would be a suitable moment for you, we'll take the break now. We take a break and we resume at 25 minutes past 1 o'clock.
All right, we will.